wasting money on cures. Forgot how to fix myself. They say that time is free. Then why is it so precious? Oh, I'll save memories in my head, like Polaroids on walls. They remind you to look ahead. Time is running out. Time is running out. Lately I've lost my track. I've sailed the deepest seas, hoping to find something to bring back better times. Oh, I'll save memories in my head, like Polaroids on walls. They remind you to look ahead. But time is running out. 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 Time is running. Time is running out. But time is running out. What if my best days are over? They can't be over. They can't be over now. Time is running out. What if my best days are over? They can't be over now. Time is running out. Time is running out. Time is running out.
Good evening, it's John here from Tutors U, welcoming you along to another of our revision class for A-level law. Tonight we are concentrating on tort law. Now listen, I imagine you've just finished your paper one today and you're feeling pretty exhausted, but maybe pleased with yourself to have got that one out of the way. Do hope that the paper one went very well. So tonight we're going to concentrate on tort law in preparation for paper two. I'm joined tonight by Gemma on the left hand side of the screen and Liz in the middle of the screen. Good evening to you both.
Hi.
And I think we're ready. Shall we get cracking with the activities? Let's get going then.
Okay, so to start off with, we've got just a multiple choice question. So we're looking at Rylands and Fletcher. So Rylands and Fletcher is a strict liability tort of which kind? Please put your answers in the chat box and then we can see how we're all doing. So if you are studying AQA, then this is, you are used to your multiple choice questions in questions 1 to 5. So this will be a pretty easy one, hopefully, if you got this in paper 2, which is coming up shortly. Okay, so do pop your answers in there. We've got a few coming through already. Shall we see if you are correct? Of course you are. It is D, nuisance. Okay, fab. Okay, so moving swiftly on. Again, put your answers in the chat box. Which of the following would be classed as a dangerous thing in a claim under Rylands and Fletcher? So which of those would be classed as a dangerous thing? Hazardous item, a non-hazardous item if stored in bulk, anything likely to do mischief if it escapes, or any of those things? D. Which would it be? have a look at the answer. Let's see. D. So a dangerous thing could be a hazardous item. It could be, an explosive. It could be fireworks. It could be petrol. It could also be a non-hazardous item if it is stored in bulk. That could be classed as a dangerous thing. And of course, anything likely to do mischief if it escaped would also be classed as a dangerous thing. Okay, well done to those who got that correct. Moving on to question 3. So there's got to be non-natural use of land. So what does non-natural use of land mean in Rylands and Fletcher? Does it mean man-made, artificial, extraordinary or not commonplace, or does it mean all of those things? Again, put your answers in the chat box. We're getting some correct answers through already, I can see. Okay, let's go to reveal. Of course, it is C. So in Transco PLC and Stockport Metropolitan Borough Council, that definition of non-natural use of land was given as extraordinary or unusual. And that's why the claim in Rickards and Lothian wasn't allowed, because it was seen to be an ordinary and reasonable use of the land there. Okay. Let's go to question 4. So what type of damage can be recovered in a case under Rylands and Fletcher? So what can you claim for? Can you claim for property damage? Can you claim for personal injury? Can you claim for financial harm? Or can you claim for reputational damage? So what are we claiming for here? I think we've got quite a few correct answers coming in there. It is, of course, damage to property. Yes, so there will have been the dangerous item which has escaped and caused reasonably foreseeable damage to some other lands. Okay, so it will be some form of property damage that is claimed for. Okay, well done. And then question 5, this is the last question here. Which of the following would not be a defence to a claim brought under Rylands and Fletcher? So would not be a defence. Remember, if those studying AQA the multiple choice questions, you have got to watch out for if they say, which of these would not be. Okay, so we got statutory authority, prescription, act of God, act of a stranger. Which of those would not be a defence? Okay, and remember, we have got to look through and consider any defences for giving a complete answer in a question. Go fully around it and see, are there any applicable defences which come up in the scenario? Okay, so which would not be a defence? Let's have a look. Yes, prescription would not be a defence here. Okay, so we do have act of a stranger, which would work as a defence. You might have covered the case of Perry and Kendrick's Transport for that one. Act of God, so anything here, any natural event, so earthquake, something like that, although it is unlikely to see those in England. And then statutory authority, if there is an act of Parliament that allows for the activity to go ahead, then that will be a defence. Okay, well done to those people who got that correct. So now moving on to our second activity, which is 5, 4, 3, 2, 1. Okay, so you've got 2 minutes to answer these questions. Jot them in the chat box. So I want you to list in the chat box 5 existing situations where a duty of care exists, 4 risk factors, 3 potential breaks to the chain of causation, 2 tests of causation, and 1 the standard of care expected. So here we're going back to probably what you studied back last year in your course, looking at negligence. Okay, so jot your answers in there. Okay, and we'll see how we go. So we've got
5,
a little bit of music playing.
4, 3, 2,
Counting us down.
1.
There we go. Jot your answers down as we're going through. Extra points for if when you're jotting your answers down, say on risk factors or existing situations where a duty of care exists, if you can put the actual case that supports what you're saying. Remember, we have got to put down the case authorities, substantiate our answers with some law. So good practice to do that here in what you're typing down. And remember, these are all elements that you'll have to consider if you do have a negligence question. So you'd have to look, are there any existing situations where a duty of care exists, and then looking if there are any potential risk factors or potential breaks the chain of causation. Okay. You only need to cover those, remember, if they come up in the question. So, only cover the risk factors that are relevant. You don't have to go through all of the risk factors, just those as they present themselves in the question. Your test of causation, of course, you need to go through those. And the standard of care, of course, you need to go through that to determine whether there was a breach of the duty that was owed.
5,
Okay.
4, 3, 2, 1.
Okay, so pop your answers in the chat box there as we go through the answers. Okay, so 5 existing situations where duty of care exists. So of course you're going to be starting off by establishing, is there a duty of care? And Robinson tells us that we should be looking to see if there's any existing situations where duty of care exists. We don't need to go through Kapara and Dickman 3-part test to establish a duty of care if we know there is an existing situation where duty of care exists. So of course there's just 5 examples, there are more. So we know between doctor and patient duty of care exists. You could maybe be looking at the case of Boland there to support that. Between manufacturer and consumer, Donoghue and Stevenson. So between any manufacturer and consumer, if it was a manufacturer of, a laptop or an electrical item, they were a duty of care to the consumers who are utilising that item. There's a duty of care between teacher and students, between chef and diners. There's been some case law on that emerging. If a diner tells a chef of an allergy that they have, then they do owe them a duty of care when preparing their food. And of course, there is a duty of care, not just between driver and passengers, but between all road users, so between drivers and pedestrians, for example. And the case example we would use there, I'm sure we're all aware of that, is Nettleship and Weston. Okay, well done for any of those that you got down. So risk factors, these are 4 risk factors which you could be looking at. You could be looking at the size of the risk, the likelihood of harm. Might be looking at Bolton and Stone, maybe as a case example there. Practical precautions, or the cost of taking practical precautions. Special characteristics of the claimant, perhaps looking at the case of Paris and Stepney Borough Council to support that. And then any social utility or public benefit. As I said, you only need to be addressing the risk factors as they show in the scenario. Okay. So three potential breaks the chain of causation. So these are potential. They may not break the chain of causation, but if they do occur, then you need to consider them. So you could be looking there at acts of nature, acts of a third party, or acts of the claimant. Okay. 2 now. Tests of causation. Of course, you need to go through your tests of causation, your factual and legal causation. I wonder if anybody can type in the chat box the case examples that you would use to substantiate factual causation and legal causation. If you can put those in the chat box, that would be great to see, because you do need to go through those. Yeah, we're getting some answers in there. Brilliant. Barnet and Chelsea and Kensington Hospital is one case that you could use there. Well done. Yes, a few people in there. Well done. Wagon Round also coming up. Okay, and then the final one. The standard of care expected is the standard of the reasonable man. Of course, that is the standard that is owed. Okay, well done for anybody who answered all those, and for those who got those correct, and for if you put any case law examples in there as well. Okay, we'll move over to Liz, who'll take you through some other activities now.
Okay, great. Thank you, Gemma. Great to see so many good answers in the chat there. So our next activity is the big reveal. So we're going to see if you can work out what is hidden behind the question mark, and we've got a list of clues. So, you know, the more clues that have been revealed, the easier it will be. So it'll be great to see if some of you can have a go at answering with the just the first clue. So we will reveal clue number 1. So I was heard in 2018. So does anybody know of anything that was heard in 2018? The phrase heard kind of suggests the nature of what we are trying to reveal. Okay, we'll reveal number 2. The defendants were the police. So in tort, you quite frequently see cases against the police. So if you see, you know, a name versus chief constable of somewhere, that is, they are, you know, making a claim against that police force. Okay, number 3 was decided in the Supreme Court. So that's going to give you the biggest clue that we're looking at a case that was heard in 2018, and the defendants were the police. We'll reveal number 4. Redefine the use of caparo and Dickman in negligence. So that is again a very, very big clue. You probably, some people are starting to get it, know what we are talking about. Really, really important. And it's really important that you have this update, you understand this update. It's not necessarily in you know, textbooks and in all the literature if it's a little bit out of date. We'll reveal the last one, the last clue, which is establish a test for determining duty of care. And I think, yeah, you've got it. We can reveal the answer is Robinson. Robinson versus, and well done, yeah, one person here from 2018. Robinson and the Chief Constable of West Yorkshire Police is our current authority for duty of care. There is absolutely no situation where you should be working your way at length through Caparo. There is, Caparo established a 3-part test. Well, we mistakenly believed actually that it established a 3-part test for duty of care. Robinson told us that we have been, you know, lawyers, law students, barristers, misinterpreting it all the way along, that actually that we use an incremental approach to establishing a duty of care. And the first thing you have to look and see is if there are any existing precedents. So in the exam, you would say, you know, in order to establish a duty of care, we use the case of Robinson. The first thing that we do is look to see if there are any existing precedents. It's really most likely in your exams it's going to be an existing precedent. If not, then you reason by analogy. And then if not, you consider a range of factors, you know, and you can refer to the Caparo criteria in order to determine if it is fair, just and reasonable to establish a duty in a novel situation. Okay, we are now going to go into a bubble quiz. So this is a little bit like the multiple choice activity at the start, but the difference here is that there can be more than one correct answer. Okay, so if we reveal the first one. So we are moving on to occupiers liability. Occupiers liability is a massive topic within tort law. And, you know, if you compare, you know, you're probably all, as was said at the beginning, exhausted from your Law 1 paper this afternoon. There's lots of topics, you know, you've got your non-fatals, your fatals, your theft and robbery, your attempts, lots of different offences within there. Tort is a lot narrower, you know, there are fewer substantive areas, so it's really most likely you're going to be asked about all of them. So, who is an occupier of property for the purposes of occupiers liability? If you pop your answers in the chat. Yeah, so lots of people have got it. If we can reveal the answer is A. So, whether you're going through the 1957 Act or the 1954 Act, you use the same structure, okay? So, you use identify the liability and the issue, and say you explain and apply occupier, premises, and then has the danger being created by the state of the premises, and then you move on to think about the type of visitor. So you will use the same definition of occupier and premises for both statutes. I'm just gonna, somebody has asked, do you need to put the date for all cases for top mark ban? No, you don't. There is absolutely no requirement to put dates. So that's entirely your choice. Okay, we will move on to the second question. What is the definition of premises under section 13A of the Occupiers Liability Act? So if you pop your answers in the chat, this is almost a trick question, but I will let you have a go at the answer. Really important just to highlight, within this question, it says section 13A. If you are aspiring for those highest marks, then you should be, remembering and recalling those specific section numbers. What's contained within those sections in the statute, you don't need to learn word by word off by heart. It's the key phrases within it. Yeah, and well done, as we can reveal the answer here is D. What's interesting about this is that the term premises isn't actually specifically defined, but this section makes reference to any fixed or movable structure, including any vehicle, vessel and aircraft. So, you've got that reference, and it's really broad what's been regarded as premises. A ladder, a stack of boxes. It's not our, when we think of premises, you think of a building. This is a structure, and even a movable one. Okay, so move on to the next question. Who would be a lawful visitor for the purposes of the Occupiers Liability Act? So we've got the 1957 Act, which legislates for visitors, the 1984 Act, which legislates for trespassers. Really important that you understand which one is which, because if you go through the wrong one, it's going to, impact upon your availability to get the marks. So yeah, some answers going in the chat. Well done. So we can reveal that the answers are, A, B, and D. So, a parcel delivery driver has got, those kind of conditional rights of entry to enter for that purpose. A repeated visitor, somebody who is a visitor, they're lawfully allowed to be there. And then a police officer with a warrant has got statutory rights of entry. So, you could be an invitee. You can be a licensee, somebody who's implied onto, permission to be on premises for a particular purpose. You could have statutory rights of entry. You could have contractual rights of entry. If you buy a ticket, to attend an event in a venue, it gives you contractual rights of entry. Okay, we'll move on to the next one. So who could be a trespasser? Okay, again, so somebody's asked, is this OCR? So this is just a general tort kind of content revision blast for you. If you pop into the chat which you think could be a trespasser, and we can reveal that the answers are A, B, and D again. So, whether you are a trespasser or not, people often assume it's to do with how you've entered the property. If you've got a key, you're not a trespasser. Not necessarily the case. So, whether you're a trespasser refers to your rights of entry. Do you have a lawful right of entry? So, you could, lawfully go into a supermarket, but if you go through a door that says no entry to customers, you are then a trespasser in that part of a building. So, a customer who stays after closing has exceeded their permission of entry. The same with a student going into a staff room. A window cleaner who goes on the roof, unless they're going on a roof, in order to clean some windows, they're probably going, somebody said quite right, beyond the, the permissions of their entry. So when you are a visitor, you are not an unlimited visitor. If you're invited into somebody's house, you're not invited to go into every room, use all of their stuff and do whatever you like. You are invited. There are limits to the purpose and, time, duration and nature of your entry. Okay, if we move on to the next one. So, which of the following forms part of the trespasser test under section 1.3 of the Occupiers Liability Act 1984? So if you pop your answers in the chat, really big difference. The 1957 Act, if you're a lawful visitor and there is an occupier of premises and that danger has been caused by the state of the premises, section 2 says you are owed a common duty of care. It's not all are you, aren't you? You are automatically owed that common duty of care. The 1984 Act, really different. They're attested at, the 1984 Act says you might be owed a duty of care as a trespasser, but there's a 3-part test. So we can reveal that the answers are, we've a bit of a trend here, A, B and D, we'll have to mix this up. Yeah, so you have to prove, that the occupier is aware or ought reasonably to be aware of the danger. Again, they were aware of or should reasonably have known, that there were reasonable grounds to believe that there were trespassers in the vicinity. And then the third part of the test is, the risk is one in all of the circumstances of the case that you would reasonably expect them to offer some protection. And that's, to do with like the nature of risk, the likelihood of harm, the type of people who are likely to come into contact with it. So, you've got a lot to do in the 1984 Act. If you're working through that in the exam, you've got to define and apply who's the occupier, define and apply what the premises are, identify that the danger's arisen from the state of the premises, identify the trespasser. Then you've got to go through these 3 steps, and then you've got to, briefly refer to breach and damage. Okay, so we shall then move on to the next activity, which I believe is the last one this evening. So vicarious liability is, it's a challenging topic. It's often the topic that's taught last, and I know it's, there's a lot of discussion within vicarious liability. There's a lot of common law. So we will get the timer going and see how many cases you can put in. Okay, 30 seconds is not a long time, but yeah, there's been some really, really good cases in there. Because vicarious liability is it's a common law area. There are no statutes. It's also, it's a very broad area because, vicarious liability is a means of establishing liability rather than independent tort itself. And it can apply to so many different kind of cases, contexts, situations. We know it's gone beyond the employer-employee context now. It has to be really, really broad, and that does bring a little bit of kind of uncertainty for law students. But rely upon your cases, use the structure of the 3 elements of it. And that is what I'd recommend doing. And I think that that brings us to a close for this evening.
It does indeed. Thank you to everybody who's taken part tonight. Lots of really good answers coming in from Gemma and Liz's questions. And thank you, of course, to Gemma and Liz for delivering those. If you've not watched one of these before, the PowerPoint that Gemma and Liz have been using will be available for you to download, and you go through those questions again if you so wish, as soon as I press the finish button in a moment or two's time. But just before we go, a quick reminder that we're back again next Thursday. Next Thursday we are splitting between AQA and OCR. So we've got an AQA Paper 2 exam clinic at 6 o'clock and an OCR Paper 2 exam clinic at 6:45. So just be aware of the fact we are splitting next Thursday. So come along to the one which is most relevant to your awarding body. Again, massive thank you to everybody. Well done for getting through the day, having gone through paper 1 and come along and taken part in today's activities as well. So until we see you again, from Gemma, from Liz, from myself, goodbye everybody.